Okay, I'm just going to blast this thing and, pick up as much as we can, but we'll have enough time for discussion as we go on certain points. So we're going to cover, a quick introduction. In fact, I've already pretty much given that already. Then we're going to trace the early origins and development of international criminal law. We're going to cover Nuremberg and Tokyo, the rationale behind the International Criminal Court. We're not just going to look at the structures, but also the reason, the purpose, the goals, and why the ICC might be preferable to ad hoc tribunals. When I say ad hoc tribunals, those are tribunals established after the fact for a particular situation without much planning, perhaps. And that will lead us to discussion why establish an ICC. We'll talk about the principle of complementarity, which may be new to some of you, and what that means. Very important to understand what that means in terms of the ICC. We'll also look at the crimes covered, and we'll outline the court structure so that people are aware of the ICC and what it does, the prosecutor, the trial, trigger mechanisms, basically how the thing works, because it's such a major landmark development in international law. We'll look at these other items here, which are sundry. Okay. Well, I want to start off with a very basic point, something we all know. And that is 99.999% of criminal cases are prosecuted, not at the international level, but by domestic courts. Why is that so? Anybody?
There's existing law.
That's what's there. That's what's existing. Of course, states have the primary interest to prosecute crimes within their own jurisdiction, because that's what affects the community that they're representing. If there's a murder, there's a theft, there's a rape, there's pressure, political pressure on the state to prosecute crimes locally. So, in effect, criminal law really emerged from a very local interest and a very local application. And customarily, and there's a document, the Harvard Research Draft Convention, you don't really have to know that, it summarizes what are the customary basis upon which domestic courts exercise criminal jurisdiction. To put it very simply, how do most countries deal with crime? On what basis? On what jurisdictional basis? Well, territorial, obviously. If there's a crime committed in the territory, within its state territory, the state says, oh, that's our matter, that's our deal. It's not for Senegal to try to prosecute crimes committed in Albania, or for Hong Kong to prosecute crimes committed, in Canada or in Saudi Arabia or in someplace else, normally speaking. Nationality. It's another ground for asserting criminal jurisdiction. If the offender was a national of the state. So these are commonly recognized bases. All countries use these. Most countries recognize also a protective principle, where the state can show that its national interest has been threatened by the offense. Most states say, oh, we better prosecute that. Even if it was committed, the crime was committed by a non-national outside the state's territory, they say, wait a second, it still affects our national interest. Well, you can go very far with that if you look at the U.S., which tries to prosecute crimes around the world because they say that it's affecting their national security. That's going too far. Here, we're talking about extraterritorial application of law, which is, I would say, illegal, goes beyond the limits of state sovereignty. So there are limits to that. Universal jurisdiction. You may have heard of this, universal jurisdiction. It's a concept that for certain offenses, in other words, certain particular crimes, that any state has a right to prosecute the offender, regardless as to where it was committed, that's a territorial nexus, or by whom, regardless of nationality or even which national state interests might be involved. It's the sense that certain crimes are so bad that they affect the international community's interest. And that's quite remarkable. And we'll trace that a little bit as we go through the historical development of the law. Then there's another basis for criminal jurisdiction, which is not invoked by all states. That is the passive personality principle. That is that some states say, well, if one of our nationals was a victim of a criminal act, in other words, the injured person is our national, we can also assume jurisdiction. Now many states don't bother invoking that, because if you're traveling abroad, you commit a crime, let's say you're injured in Thailand on holidays, and it's better that the Thai government prosecutes and takes care of that case rather than, let's say we're all from Hong Kong, that Hong Kong starts to try to get evidence, get witnesses, and try to prosecute that crime because it was a Hong Kong person injured. Normally there might be some diplomatic conversations or some demands for compensation, but it's rare that a state, without being connected by territory, nationality, or national interest, would then say, we're going to prosecute just to protect our nationals everywhere. So that's passive personality principle. Any points, any questions up to this moment? Crystal clear? Yeah? I told you it's going to be a hard duty, heavy-duty university lecture. Okay. Well, after we've reviewed all those bases, yeah, go ahead.
Some states said they decide to prosecute pedophiles.
Yes?
Even though they committed it in another country.
Yeah.
Where would that fall in?
Well, it doesn't necessarily fall in. If they prosecute pedophiles, it should be either because they committed crimes within the territory or it was their national, just as we have here. Unless at a certain point the international community recognizes that pedophilia is an international matter of international concern, subject to universal jurisdiction, that might allow any state, regardless of these other bases, to prosecute. But that's not the case yet. It's not that the international community doesn't care about pedophilia. It has to be of a certain seriousness and import to the international community, because otherwise states are there to prosecute crimes, with the closest connection to them. That makes common sense. They're there to do that. They have tax-funded courts to do it. It doesn't make sense that a state prosecute cases very far away, unless it has an international dimension. For example, with regard to trafficking, or there's a network, or this kind of thing, which crosses borders. But then we're not talking about international criminal law in the classic sense that we're going to talk about it today. We're talking about mutual cooperation in criminal matters. That is state cooperation bilaterally. And that's another field of law, for example, to deal with pedophilia, perhaps, pedophilia rings, internet crimes, counterfeiting, cutting of underwater cables from the Atlantic, across the Atlantic and the Pacific. I don't think there are any underwater cables across the Pacific. There may be some. And those are where states have to cooperate on a bilateral basis. It's a different thing from saying this is a matter that's of concern to the entire international community as a whole. Okay? All right. So, well, we've talked about just now, states have all these, they have police, they have courts, they have all these territorial bases. Do we really need international criminal law? If we don't establish that, maybe the rest of my lecture is a bunch of nonsense. Because if there's no need for international criminal law, we already have state jurisdiction. Why do we need international criminal law, do you think? Or do we need it? Maybe we don't need it, and then we can go home and we can go back upstairs and have more fruit and drink and stuff.
In some cases, the state simply refused to fulfill the obligation.
Yeah, I mean, you could have that situation where a state is unwilling to deal with the crime, right? Can you think of a case or an instance or a situation? Pinochet, Yugoslavia, where the state itself is criminal, where the people in government are the criminals, or they're complicit, or they protect the individuals who are criminals. Saddam Hussein. Well, he's in jail now, but exactly right. But Israel, perhaps. Israel, with the Sharon government, has been perpetrating a lot of violations of the Geneva Convention 4, and other serious violations in occupied territories and other places. It's a good example. In fact, when I was at the UN, somebody called me up and said, actually they're on the web. It's called Indict Sharon. They asked me, what does the UN think? And I said, I don't know. But I told them, listen, the UN has a good track record of saying at least that the action in the Israeli-occupied territories, for example, Palestinian territories, Israeli-occupied, is illegal. They're on record for a long time. Problem is the politics in the Security Council and elsewhere. But that's a side issue. We could talk much more about it another time. But what are the reasons? So unwillingness. The state may be unwilling. Can you think of another thing?
Well, uniformity. If maybe one state would decide to prosecute, maybe it would be half-hearted.
It could be. And,
Standards.
yeah, okay. Could be very low standards. So they may need more objectivity, fairness from an international institution. So the state itself might need assistance. You have that example right now at the International Criminal Court. The government of Uganda has requested the prosecutor of the ICC to help it prosecute crimes, to help Uganda take cases against the Lord's Resistance Army that is hacking off limbs and wiping out people in villages. It's a rebel group they can't deal with. It's been going on too long. They say, look, we need the help of the international community. So that's another situation. Can you think of another one which is related to that?
Rwanda, unable to do the
Yes. Rwanda, unable. And I told you before that worked quite a number of years on Rwanda. That's a situation where 80% of judges and lawyers were murdered. Why? They were targeted particularly by the Hutu militia. That was a genocidal group, in order to prevent prosecutions from taking place. When I went down to Rwanda, I was amazed that, not only were there no judges and lawyers, very few, but also judicial premises, courtrooms were smashed because they wanted to prevent prosecutions and also any witnesses and all that. I have a PowerPoint on Rwanda, but it's so bloody, I don't show it to you, especially after lunch. So, but let's take a look at these. So, a state with jurisdiction to prosecute may be unable. That's the case of Rwanda. Everything, there was a genocide, breakdown in the state, and so Rwanda needed assistance from the international community. A state with jurisdiction to prosecute may be unwilling. For example, some of the successor states of the former Yugoslavia started to shield their war criminals. For them, they weren't war criminals, they were war heroes. A state may need help to prosecute. And here we already took this example. An international criminal tribunal can add objectivity and fairness to the criminal proceedings, as well as raise their symbolic profile. If there's ethnic unrest and you're having to prosecute the leader of an ethnic minority in your country, it may be so politicized that you need an added element of objectivity and fairness. Okay, so somehow I divined that you would come up with all those answers because you did in the same order, but that was by luck. Okay, another one we didn't mention, however, was the following. An international tribunal can get help in gaining custody over the alleged offender. A lot of people commit crimes in one state, they cross the border, and they say, bye-bye, that was fun. Okay, we did something we regret. We murdered 1,000 people, but now we're safe. We go to somebody that likes us, or that will protect us. An international court has much more clout to get hold of an alleged offender. Okay. People are, here it is again. Just teasing you. Okay. Try to take it down in shorthand so we can move along. And we can always come back later to it. Okay? Yeah? Got it? All right. That follows from that the goals of international criminal law should be what? What do you think? What should the goals of international criminal law be? Basic ones, even for criminal law.
It should be universal.
Universality should be important. Very good. It's a good one.
you have to take responsibility for what you have done.
Exactly. Enforcement of individual criminal responsibility. So there's no impunity. Otherwise, if you have a climate of impunity internationally, that encourages people to say, well, I can get away with this. Right? Excellent point. Anybody else? How about a basic one? Stop the ongoing violations. If you can prosecute, if you could be effective in getting hold of the perpetrator, you can prevent ongoing violations. So that would be the first I would say. Halt ongoing crimes by arresting the criminal suspect. And thereby also to deter crimes from being committed by others in future. People see that you have an effective system of international criminal law. They'll say, well, I better think twice about committing such crimes. Try, sentence, and punish the criminal according to recognized norms of international law and justice, due regard to ensuring witness protection. Okay, that's just to say that there should be enforcement of individual criminal responsibility. Ensure compensation for the victim or victims, if that's possible, instead of just saying, well, okay, we prosecute a person, but what about all these thousands and thousands and thousands of people in Rwanda that never got a dime after the perpetrators, some of whom were locked up, but they still didn't get even $25 US, which would have helped them a lot, just to buy seed to, that didn't happen. Foster rehabilitation of the criminal. It's not just about vengeance or retribution. That's not what we're talking about. It's also, hopefully, and it's hard to imagine in cases of massive war crimes, mass rape, ethnic cleansing, genocide, that some people could be rehabilitated. But at least that should be a goal. Otherwise, we're just talking about vengeance and retribution. It's very important in criminal law in general, so that we treat people with respect, and that we say maybe these people could be corrigible. Emphasize individual responsibility instead of collective responsibility. That's a very important point. It looks a little abstract, but in fact it's not. The fact is that if you don't have individualized criminal responsibility, what do you have? Well, let's take Yugoslavia. You say, Bosnian Muslims said, it was those guys, it was the Serbs. It was them. Of course, you just had a village wiped out. All your neighbors were wiped out. You're a survivor. You say it was them. And they say, but it was them. Think about what happened during the Second World War. It was the Serbs who suffered. Or look around Asia. You could take any example here between ethnic groups. People tend to say it was them as a collective. That's how the violence continues. Because they say, well, I'm going to take a slam at any one of their side. And it may not be tomorrow, it may not be next week, it may not be next month, but I'm going to be waiting here. You hate the whole group because you don't see that it's an individual who committed the crimes. That's something very basic about human nature, especially when you've suffered a lot, especially if it's war crimes, crimes against humanity, genocide. These are big crimes. You say they're all bad. And but if you say, well, wait a second, there were good Serbs and bad Serbs, and you document it and you show, that dissolves collective responsibility. And that's much better. There's another thing at the international level. There hasn't really been individual criminal responsibility. It's been mainly responsibility against the state. But that's a wider point about international law. Okay, historical background. Let's go directly to get the historical sweep of how international criminal law developed. I mentioned in an earlier lecture, the very first day of our course, that there were some ancient religious codes. And I promised to come back to that, and here I'm coming back to it. And that is that in ancient norms, in China, India, Greece, Rome, I could have mentioned Egypt there as well, and later in the Sharia law, and in different religious codes, you find certain councils that say, look, you're winning the battle, or even if you're losing the battle, you can't wipe out women, children, elderly, sick, wounded, prisoners of war. Don't wipe them out. Let them on their way. Can you think of any reason why? That's a very radical question I'm asking. We assume it's for what reason?
Reciprocity. You don't want it happening.
That's a good point. We're going to come to reciprocity back. There is reciprocity, a factual reciprocity. There's another very practical point. Put yourself in the field. If you're a commander and you want to get that hill, and you've got limited resources, right? And that's in the old days, ancient wars, tribal wars even. What do? You struggle away, you use your implements. Now, if you start wiping out villages,
You're disrupting your own supply chain.
Brilliant. You're interrupting your own supply chain. That's one thing. You're also spending a lot of extra energy for nothing. It takes a lot of energy to kill somebody, actually. Okay, these days it's right, but that's a high technological advanced societies doing that. In the old days, it took a lot. Even in Rwanda, it took a lot of clubbing, a lot of machete slashing. Very little was done by machine gun. So you don't waste time. And also you don't get the population against you. So from basic, forget about humanitarianism, from basic common sense of military requirements, it makes sense to streamline your effort. Go for the tactical objectives and achieve your goal. So it's not just humanitarianism is my point. It's also humanitarianism. I don't want to just say it's not. But however, implementation has been often scarce. So you see some cases in ancient Hindu law and in China, but it's always been uneven. It's more moral, religious codes, not as legal as. And I mentioned already between a balance between military necessity and humanitarianism. And you saw in Dr. Bottiliero's lecture on Geneva Conventions, she would have explained much more in detail about the balance between military necessity and humanitarianism. So we don't have to review that. But just to say that it's just not pure humanitarianism. There's also military issues here and requirements. I want to draw your attention that in the Middle Ages, there grew up a body of law, customary law, called the jus militare. That means the law, jus militare, of armed men. It's the law of the knighthood. Basically, certain crimes were seen as a violation of honor. Remember the knights, going around in shining armor? It's not just in storybooks. They did rely on a code of honor, so that because it was they were seen as exponents of the honor code, and so certain crimes were seen to be a violation of that. Okay, for example, you couldn't use the crossbow. Anybody know why? The crossbow is a piece of wood like this, and then you have a string, and it's very finely calibrated. The arrow goes wham, exactly where it's supposed to go almost every time. In fact, most countries still outlaw the crossbow. Canada, for example, can't use it. Why not? Since the Middle Ages, since 1,000 years, why not? Why can't you use the crossbow? Too precise at a distance. There's no hand-to-hand combat.
Very forceful.
Yeah, but there's no honor. The honor is in a sword fight, not in picking off somebody from far away. Well, we're beyond that these days. Poisoning of wells, equally, that's still law today. That's not allowed. It's not allowed because it's perfidious, it is sneaky, and there's no honor in that. I'm going to ask if there's somebody in the booth that the doors could be open, because people are starting to freeze. I see that. When we open the doors, it warms up quite a bit. Oh, you don't have to do it. I can. Yeah, okay, thanks. And then classic things: murder, rape, looting. These are all questions of violation of honor. Okay? Those go way back, those rules. Then I mentioned to you before, perhaps, or no, I suppose I haven't. This is interesting, I think. Way back in 1474, so a long time ago, there was a trial of Peter von Hagenbach in Austria. He was under the Duke Charles, and he was taking his troops through the Rhine Valley, and some of his troops started to take things. They were raped, looted, murdered. And they said, "You're responsible as the commander." He pleaded, and they set up an international court. 28 judges or so, I think it was. And they held a trial. And they said, "What do you have to say for yourself?" And he said, "I was acting under superior orders." They said, "It's not acceptable as a defense." They went on with the trial. They found him guilty. They said, "You're responsible for your subordinates." They stripped him of his medals, and they executed him. 500 years almost before Nuremberg and Tokyo. And it's pretty interesting because it's such a shining example of an international criminal court. So, I jump now to 1815. Well, because there were a number of codifications and law developed, but we don't have time to go into all the interesting history. If we take a course in international criminal law that I do teach, you can always learn that in depth, but we don't have time to do that. But I want to highlight for sure the Congress of Vienna. This is the Congress held, obviously, in Vienna in 1815 to settle the post-Napoleonic war peace settlements. I mentioned it in our very first lectures here on human rights. It was also the start of the international law of cooperation. It was the first time states said we're going to get together to cooperate on certain things like railway widths, navigation of the rivers in Europe, and a few other things of standardization. But they also took the responsibility in Vienna to outlaw slave trading and piracy on the high seas. Those were two of the biggest concerns at the time. And they said that states, any state, should be authorized to prosecute these crimes. Why do you think they said that with regard to slave trading and piracy? Why do you think these countries said we need universal jurisdiction? Forget about territoriality, nationality, all these other things. Universal jurisdiction is the idea, remember, that any state could prosecute, regardless nationality or territoriality. Why? Yeah, that's one reason. And look, the high seas. High seas is known in international law as territory res communis, beyond the sovereignty, the territory of any state. That means nobody would prosecute them. You remember these pirates? They have, a patch, right? And they fly a flag. The flag is the skull and crossbones, right? They don't fly the flag of the national state. Similarly, in South China Seas, you have in the Malacca and also around Singapore, pirates. They don't necessarily have the thing with the parrot going whack, 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 and the whole thing like that. But they're beyond the state and they're doing illegal activities. So they can't be prosecuted as a national in that way. Maybe they have a nationality. Nobody knows what nationality they are. And these crimes are committed in res communis. Okay. We're still with this. The other major development was the U.S. Lieber Code. It's interesting, I think, that during this American Civil War, actually Francis Lieber, who was a European, was asked to draft a code that would apply to the Civil War and which prohibited arson, murder, maiming, assaults, highway robbery, theft. You don't have to get the list down. You can just catch these things on the internet anytime. Basically crimes, to prevent war crimes. And that was way back in 1863. And it was a modern, a forerunner of modern military codes. The idea picked up that, for our militaries, we should be able to have some kind of code to say you can only go so far and not to commit these kinds of crimes, even during war. There's the 1899 and 1907 Hague Conventions. These conventions, there are two big peace conferences held in The Hague, the Netherlands, was the first codification of the laws of war. And I should have mentioned 1864, you have the emergence of the Red Cross in Geneva, the founding of the Red Cross in Geneva with a committee of 5. And that happened just a year after the Lieber Code. That gave rise to the whole Geneva Conventions. That was 1864. You don't have it here. Okay. But you had a whole lecture on that in depth from Dr. Bottigliero. Okay. Here I can go very quickly on this. The Hague Conventions basically establish the right of belligerents to say that it's not unlimited. You can't do anything in wartime. There are limits to wartime. And certain means of warfare are expressly prohibited. And a state that resorts to unlimited warfare may have to pay at the end of the war an indemnity, some kind of compensation. So these conventions codify those customary norms. Okay? It also prohibits, here's this important, seizure, destruction, or intentional damage to historic monuments. We saw so much. Remember the photos I had when I was, we talked about human rights, about the destruction of this after the Second World War. We don't need to repeat those. Churches and temples and synagogues completely wiped out, gone forever. Well, there are specific provisions in conventions prohibiting those kinds of massive destruction. All right. The Treaty of Versailles marks the founding of the League of Nations, the forerunner of the United Nations, 1919, and that treaty actually has a provision in it, Article 227, to prosecute the former Kaiser, Emperor Wilhelm II of Germany. It's the first time that a treaty says we're going to try that guy for starting the war. Before it was always, okay, you pay money, you pay money. This time they said, this guy's personally responsible. Even though, if you look at the circumstances of the First World War, one can argue whether that was really fair, because historically all countries kind of drifted to the war. It was not like Hitler in this case. But okay, they said, you should be tried and punished for starting war, which is a supreme offense against international morality, sanctity of treaties. But this provision was never executed, because he made a deal with the Netherlands. He said, listen, can I come over there? I think it's getting hot where I am. And they said, come on over here, we're neutral, and we're not going to prosecute you. And he lived out his long days in a fantastic castle. So he was happy there. The point is, however, that Article 227 at least symbolized the possibility that a head of state might be held personally responsible. That's very radical. Because before that, state sovereignty was very absolute. A head of state, I mean, king or queen or president, really enjoyed absolute sovereignty for so many centuries in Europe. You had this doctrine of state absolutism. But here things were starting to change already. Okay, but there's something else that happened. Well, these are the Leipzig trials. Has anybody heard of these before, Leipzig trials? It's quite fascinating, and it has a lot of relevance for us today. And that is the following. That there were some articles in the Versailles Treaty, Articles 228 to 230, where the German government was recognized, or I should say they recognized the right of the Allied powers to try persons for war crimes. They said, look, a lot of your German soldiers perpetrated war crimes during the First World War. So they said, you better surrender them to us, and we're going to have prosecutions. Okay? What happened was, this is way back in 1919. It's not in the days of email, internet, and conferencing, and CNN, and everything else. So Germany says, listen, we'll prosecute our own nationals. Okay? And in those days, I mean, try to translate everything into from German to English to French. So people said, okay, the Allied powers said, we did this war, the war's over, let Germany do it. What do you think happened? Anybody? What was the result of the Leipzig trials, of these war crimes trials? Let's take a look. The Allied powers were asked to provide a list of 901 suspects, almost 1,000. They said, here we go. We have evidence or allegations of all these people. Okay. The Leipzig trials were held at the Supreme Court in Leipzig. That's why they're called Leipzig trials. 888 were acquitted or summarily dismissed because they're being done in Germany. Germany just fought the war. These are the good old German boys. So they said, we'll prosecute them. Ha, ha, ha. Right? Acquitted or summarily dismissed immediately. 13 convicted, but no sentences actually served. Several escaped from prison. In other words, it was a sham. It was a joke. A very nasty joke on the Allied powers. So that's something I think interesting, and it's a very, very important lesson for today, that if you leave prosecutions of war crimes where there's a political element involved, and the state was involved, the state will find an easy way out. These are war heroes to them, not war criminals. So I come back to that point. At least at these days, you can still get away with that. Now we jump already to Nuremberg and Tokyo International Military Trials. So we're doing the sweep of history, so we have the context. Okay, at Nuremberg, 22 German nationals were tried. Look, a small number, eh? 12 sentenced to be hanged, 7 imprisoned, 3 acquitted. Now, can you think of why there were so few prosecuted? What was the philosophy of the Nuremberg trials? Anybody?
Symbolic.
Yes. So who did they go after?
The real nasty ones.
That's it. Exactly right. They went not only the real nasty ones, but they went after leaders and organizers. Cabinet ministers, industrialists who made the war possible, top commanders. Okay? And then the trials were followed up by thousands of domestic level military trials. in each of the occupied territories and elsewhere. Okay? So this was just to make the point, and then it was followed up. At Tokyo, same thing. 28 Japanese nationals were tried, 7 sentenced to be hanged, 18 imprisoned. 1 died during the trial of tuberculosis, 1 died of natural causes, 1 was released for, he went nuts. Okay? Now, the Nuremberg and Tokyo military trials were very spectacular, because here you're putting on trial members of a government. Never been done before. We had some hints of that happening in the Versailles Treaty, but that was never executed for Kaiser Wilhelm II. So the landmark developments, because they've established the illegitimacy of Axis aggression. You can't say that just it's one state fighting with another state. All states are equal. Go ahead.
Is there any Americans trial at Tokyo?
We're going to get to that. We're going to get to that in a moment. The principle of individual criminal responsibility. So that point that you raised earlier, that you have to make the point that individuals are responsible. It's not just the state. For crimes against peace, that is starting a war. War crimes, that's rape and murder and killing and looting and all those kinds of things. Crimes against humanity, regardless of official rank or capacity. Doesn't matter how great you are, nothing protects you. The inadmissibility of the defense of superior orders. Why do you think superior orders is inadmissible as a defense? What's the rationale behind that? Anybody? Focus on that for a moment. Why do we say that superior orders is no excuse? Why?
Because you have common sense and as a human you have a responsibility.
Okay, but you know, realistically, if you're a soldier, let's say in Sri Lanka, and you're under orders, and military discipline is very harsh, and you say, no, I think I don't want to hurt those people because they're my fellow human beings. What are they going to do? They're going to shoot you maybe, right? I mean, shouldn't you have a defense if you're prosecuted? What do you think? Anybody? What's the rationale behind this?
Is it, again, to uphold the highest level of morality?
It is. What would be the alternative? I mean, somebody? Think about it for a moment. I don't want to just barrel ahead. Yeah, but how can you be responsible if you're you're acting under orders? How can you be responsible? You're just carrying out orders as a soldier.
Conscious objection.
That's possible. Think of it this way. Think of what alternatives there are practically. Supposing you commit an offense, okay? You wipe out 50 civilians, unarmed. You line them up, and your commander says, once we leave and go on to the next village, and they're going to start feeding the soldiers. That's what they did in Lieutenant Calley's time. They tried to wipe out the civilians. They said they're giving aid to Viet Cong. They said, wipe them out. That's what happened there. And you say, look, I'm under orders, and we know military discipline in my army is they may punish me terribly. Okay? Right? So you say, I'm going to shoot them all. You look actually like a very nice person. I don't think you'd do that. But it's hard to say no. But if she says, I have a superior orders as defense, and that's admissible, she says, my sergeant told me. Well, the sergeant says, I was ordered by the captain. Captain says, it was the colonel. And colonel says, well, I ordered it. That's true. But it was the general. He ordered it. Right? General was 3-star, 4-star, 5-star, goes up the line. And then they say, General, you gave all these orders all the way down. You're responsible for this. So first of all, I didn't hardly know that these violations were being committed. I wasn't even there, number one. Number two, I was under superior orders. I say, oh, not again. From whom? The president. And I say, President, you're responsible for this. Sorry, I have state immunity. You don't prosecute anybody. Nobody's responsible. With state immunity and superior orders, everybody's happy, except the victims. So you have to say, look, the individual has a role to play, and a very important role. And if you have a knife in your back, that's duress. You don't have moral agency there. But so it depends on how much force. If the military discipline, I'll take a ridiculous example. They say, shoot all those civilians, or you don't get your week of cookie rations. For 1 week, you're not going to get cookies. That's ridiculous. You should be expected morally to say, forget about the cookies, I'm not shooting civilians, unarmed civilians, right? But if it's something more difficult, like we're going to shoot you, you might have a defense. The way that the Nuremberg and Tokyo trials dealt with this, with the ICTY and the ICTR also, they said you can't use it as an absolute defense, but it can be taken into account in terms of mitigation of punishment. A very interesting case where a young, impressionable guy named Erdemovich shot 120 people or so. He was under orders. He knew that if he didn't shoot them, he would be shot because one person had already objected. They had been shot. He was a Croat. And he tried to object, and he almost got shot. And he was very, very depressed about it, and he cooperated. He turned himself into the tribunal, and they said, you're still guilty because you shot all these people, but we're going to give you a lighter sentence. It's the only way to strike the balance. If you go with an absolute defense, nobody gets prosecuted. Go ahead.
Well, in the Nuremberg trial,
Yeah.
they were part of the bad guys. So unlucky for them. But what about for Americans who
We're coming to that.
were bombing?
The Americans were coming to. Everybody wants to get the Americans. Okay.
That's happening right now.
Yeah. We'll get to it. Don't worry. But they are often criticized for, being one-sided. All of the judges were from the Allied powers. Not even neutral countries were represented. And on Nuremberg, it was U.S., UK, France, Russia. And Tokyo was a broader range, but they're all from the Allied powers. All of the defendants were from the Axis powers. Not one Allied soldier. And that's how the statutes of the Nuremberg and Tokyo trials were. The charters were drafted. This is to prosecute Axis power enemy nationals, not our own soldiers. So they were one-sided. Were they victors' justice? Well, I've written 2 books on international criminal law and lots of articles, and I make the point, yes, victor justice. Let's call it what it is. Let's be honest. That's what they were. It was good that they did what they did in Nuremberg and Tokyo, but it was not good enough. They should have also prosecuted Allied soldiers. That's why when we had the human rights thing, I also showed you, just to remind people, Hiroshima, Nagasaki, Dresden, and everything else. Of course. So that your question coming from 2 angles in stereo is correct. Not only that, the criminal law is being enforced retroactively. War crimes, we saw that the norms go back to ancient religious codes. But it was never a crime to start a war. But that was never a crime. That was new law. Same for crimes against humanity, which is a new category, basically where a government commits crimes against its own nationals. We need this category of crimes against humanity because war crimes really is during war and one soldier against other soldiers or civilians. It's about soldiers who are being perpetrators. Crimes against humanity could involve civilians as perpetrator or as victim. So it's a broader category. That's why it's important. But that was new law. It's a violation of criminal law and justice if you commit an act on Monday. On Tuesday, that act is qualified as a crime. It's criminalized, penalized. They say, well, this thing that you did is a crime. On Wednesday, you created an international tribunal or a domestic tribunal. It doesn't matter. And on Thursday, they try you, and on Friday, you're found guilty. That's a violation of procedural justice. Although Nuremberg and Tokyo perpetrators, they should have known that the kind of big crimes they're doing were wrong. But strictly speaking, I'm making a strict legal point. They were not strictly illegal. So from a procedural point of view, it's a violation of criminal justice. And did the Nuremberg and Tokyo trials violate criminal justice in that sense? Yes. I'm glad they happened, but they were less than perfect. They also lacked fair trial guarantees. And, if we were doing a whole course on this field, we could go into great depth about it. It's quite interesting. There was trials in absentia where they couldn't get the hold of the person. Death penalty A trial in absentia is bad because where's your right to defense if you're tried and you're not there? The death penalty, these days we're moving towards abolition. But that's particularly serious if there's no possibility of appeal. You need an appeal, especially if there's going to be a death penalty. All right. Nuremberg principles. Notwithstanding their faults, the international community tried to draw what they could from the Nuremberg and Tokyo trials and codify them in terms of principles, which is a good thing for the future. So that, these trials were not just for the Second World War, but that you could also have something for the future. And so the Nuremberg principles are the following. Any person who commits an act, it's basically individual criminal responsibility principle. It's that. Domestic law is no excuse. These are international norms. That also answers why there has to be international criminal law. You can't define your way out using your constitution or your domestic criminal law to get you off. You can't say, well, my government passed a law that says genocide's okay. No excuse. Doesn't matter whether you're a head of state or public official. Doesn't matter your rank. Superior orders is not a defense, but it could mitigate punishment. Any person charged with, has a right to fair trial. These are the basic Nuremberg principles. Actually, those are them. You have them right in front of you. Okay? Now, after the Nuremberg principles were adopted by the UN General Assembly, there was a lack of progress during the Cold War. So, there weren't any international criminal trials until ICTY. Why? Because Nuremberg and Tokyo trials were disbanded. They had done their work. Why do you think? Why do you think there were no trials? Sorry?
Cold War?
Yeah, it says Cold War, but why? What did the Cold War do? Yeah? Right?
If one party is fighting a person, there is no other party that's a freedom fighter or...
Okay, let's put it in a different way and say that the lack of international cooperation didn't allow the field to develop. And that's a point I made before, that when we looked at the Vienna Congress, there was the international law of cooperation was beginning. International criminal law requires a mechanism to be built. It requires cooperation to get a hold of the suspect, fair trial guarantees. It requires a lot of cooperation. If you don't have that, if the international community is divided, and there's always a veto on the Security Council, you don't get the law and the institutions developing. That's exactly what happened for 40 years. So, in fact, the UN tasked the International Law Commission, a body within the UN, to develop an international criminal code and court, but it didn't go anywhere for 45 years. Just nothing happened, really. They talked and they talked and they talked and they talked. Just like I am right now, like we all are. But at least there was a Genocide Convention in 1948. We already looked at that last time. Just to remind you what it did. It outlaws genocide. It obliges state parties to prosecute it and relies on domestic prosecution. We don't have to look much more than we've said before. And you've already covered the 4 Geneva Conventions. You already have a foundation from Bottigliero's lecture. But I'll just remind you, for the first time it applied in non-international armed conflict by Common Article 3. That was in 1949. And it established grave breaches. You've talked about that quite in depth in another lecture. I don't have to repeat. But just to remind you, these grave breaches, serious breaches, are these: willful killing, torture, biological experiments, these kinds of things. Classic things that we know. Okay? All right. Okay. Now we get into present days. The end of the Cold War allowed the UN Security Council to establish the ICTY. Finally, Russia and the US didn't just veto each other all the time. And you got some possibility to move forward. And that was an exciting time. It hasn't gone as far as we'd like. A unipolar world is now being completely dominated by one superpower who's violating international law left and right. Too bad for us. Pursuant to Chapter 7 of the United Nations Charter, I mentioned to you before that the United Nations Charter allows the Security Council, authorizes it to adopt a resolution. It's very important that you take this note down. Chapter 7 of the UN Charter can adopt resolutions to take binding measures on all UN member states. You've heard that before, and it's being repeated throughout the lectures by Peter Malanzuk and Hilario Botellero and myself. It's very important. That's a legal authority upon which the ICTY was formed, was based. It was an ad hoc international criminal tribunal in the sense that it's not a permanent tribunal. It was established to deal just with the former Yugoslavia, to prosecute grave breaches of the Geneva Conventions, which you already know about, violations of the laws or customs of war. These are 1899, 1907 Hague Conventions, and customary laws. Genocide, crimes against humanity. These are by now familiar for you. And the ICTR, International Criminal Tribunal for Rwanda, in 1994. As I told you, I was involved in that process. Pursuant to Chapter 7 of the UN Charter also an ad hoc, here it says Criminal Tribunal. That's because late last night I was editing this, so I think I meant criminal. To prosecute war crimes in Rwanda, and these things here, genocide, crimes against humanity. Because it was a non-international armed conflict, it's common Article 3 to the Geneva Conventions that applies. Okay. You don't have to know the great details, just an introduction. Now, why do you think that the international communities started to say, well, we need a permanent international criminal court? Why not have more ad hoc courts? Why do you think? Why not set up, if there's a problem right now, for example, in Darfur between Sudan and Chad, why not have the Security Council could create an ICT Sudan and Chad tribunal? Why not have one for Uganda? Why not? Somebody over here? Yeah. Go ahead, yeah.
There should be a standard.
Okay. So if you have different tribunals, you get duplication, and you get maybe conflicts, and so the law doesn't develop well, right? It's a waste of resources. Yeah? What else?
Yeah, of course, can only cover one in one place, but for there are a lot of silent wars. For those you cannot handle by ad hoc courts, you have to have a permanent court.
Good classical reasoning is that each tribunal has its own temporal and territorial limitations. Exactly right. So that's a very ad hoc approach, very scattered. And, go ahead.
I was just going to say that they're reactionary.
Yeah. They're retrospective.
And retrospective.
Mm-hmm.
So much of the heat and momentum
It's past.
lost.
Exactly.
And also they are, which you mentioned earlier, they're not planned well.
Yeah, here's the inside story from the UN, you see? so he knows much more than exactly right. And so that's a problem. And then not only that, a basic point is they require the political will on the part of the Security Council each time. Just like you're saying, the momentum, exactly right, is that you have to have the political will there. And you have to have, one of the permanent members doesn't veto it. That explains why you don't have an ICTC, an International Criminal Tribunal for Chechnya. Russia's sitting there. That's why you don't have one for violations in Iraq committed by the U.S., by the coalition, and by Iraqis. Or why you have an ICTB, one for Burundi, which is just neighboring Rwanda, where there's all sorts of violations. Or why there's not an ICTDRC, or for Democratic Republic of Congo, or Dagestan. Lots of places. Because political will is not there. Ad hoc tribunals are limited in temporal and material competence. They're established mainly after the major part of violations are committed. They're essentially retrospective. Reactionary is also a good word because they react. It's not preventive. Therefore, of limited deterrent value, which means that one of the major goals of criminal law and international criminal law is not being served well that way. And they are established through an inherently politically selective process. Security Council is a political body. And, so what, you're getting less fairness and objectivity from that reason. And they are, come back to our point that was first made, less efficient. They cause duplication. They waste resources. They hinder the coherent development of international criminal law jurisprudence. If you have an ICTY, ICTR, ICT this, ITC that, you get all sorts of, who knows what the law is anymore. Okay? Can we go on? Yeah? All right. The International Criminal Court therefore, is intended to do what? Well, to be permanent, standing institution that can symbolize the international community's seriousness and commitment to prevent, punish, and deter crimes under international law, dispel the climate of impunity for major crimes. It's a different sense. It's to say it's going to be an institution that sits there. We don't have to create one because there's a bunch of violations going on, after the fact, which is not much use after they're already committed. To act prospectively, to provide a more universal presence. I'll go back to that just in case people are still taking a few notes. I see some scrambling. Ooh. Okay. Permanent, prospective, these ideas, standing, universal. Okay. Let's look at the main operating principles of the ICC. And now we're perfectly on time for that to do that. Okay. Article 1 provides that the ICC shall be permanent. So that concept we've already talked about. Shall exercise jurisdiction over persons. That means natural persons, not corporations, not states. Now, Nuremberg and Tokyo actually did look at criminal organizations. And if you're a member of that, you might be swept in, which is dangerous because that reverses the presumption of innocence. If you are a Muslim here in Hong Kong and you contribute to a Muslim group that has some religious aims, that sends some of its money to another group, that sends some of its money to Al-Qaeda, you didn't know. The Hong Kong authorities, police are going to say, oh, you're a member of Al-Qaeda or you're contributing to Al-Qaeda. And that criminal organization is listed. And therefore, you're guilty unless you can prove your way. That's how Nuremberg and Tokyo acted. They declared certain criminal organizations criminal to sweep in the membership. That's not right. That reverses the presumption of innocence. And we're doing that today with terrorism and the UN Security Council. If you presume everybody who's an Arab or a Saudi or a Muslim is guilty, it's completely, absolutely wrong and off track. So this says, look at persons, not groups, not organizations. Covers only the most serious crimes of international concern. That's very important. The idea is not here to replace criminal jurisdictions, and this is not an ICC to prosecute theft and murder and rape, which are serious crimes, but they're not of concern to the international community unless they're committed in a big way, that they're disruptive to international peace and security. This is not to set up an international criminal system in the sense of replacing domestic system. Only to look at big, most serious crimes. Be complementary to national criminal jurisdictions, which follows from what I'm saying. We're going to analyze that more in a moment, if it's not clear. Of course it won't be clear, it's just a word. Plus it's in italics. What does complementarity really mean? It's an odd word, isn't it? Let's explore it. The ICC is not intended to replace domestic criminal jurisdiction. That's the point. It's designed to act only where a state will not or cannot prosecute. Only to jump in where the system is broken down and there's a danger of impunity for major crimes, which is a very brilliant idea, right? Otherwise you have the governments taking care of this themselves, as they should. It's their obligation. It's not only a right, it's an obligation. But where that doesn't work, that's where you need international criminal institutions. In other words, to put it in a nutshell, where the state is unwilling or able to prosecute. If you understand that, you understand a lot about the ICC. It's supposed to act where the state is unwilling or unable. Okay. Too fast? You got it, right? Yeah. You have a question?
So even if the U.S. does not agree to the ICC, there's a mechanism where the international community can say they can prosecute American conduct during the Iraq invasion?
We're going to get to it. Hold on with that. Unfortunately, it's flawed. It's another U.S. question.
If any state willing, but come out very little sentence, like if will come out with 2 year imprisonment,
Right.
What will be the position?
That is a sham trial, and it's Article 16 of the Rome Statute, which basically says that if a country is prosecuting, but doing it with the purpose of shielding, and this is the words they use, shielding the accused, that's not a real trial, and the ICC can take it over. And who's to decide whether the state is doing that? Not the state, the ICC. And states signed that.
Who can complain to the ICC?
We'll get to that in a moment. You'll see the process. I'm glad that you're jumping because it shows that you're interested to see the next point. But I'll have to do it systematically. But I'm glad. Thank you for your questions. It shows interest. Go ahead. About the U.S., sorry? No.
Why the Hague about the Netherlands?
Why?
Located in the Hague.
States considered that, and it's the home of international judicial institutions of very high repute already. The International Court of Justice, the ICTY, the ICTR, arbitral tribunals, has a library, the Peace Palace there, and it's also got a strong tradition of neutrality and it's well respected. And they can provide all the guarantees of, plus they lobbied hard for it. And they said, we're going to contribute and pay. Otherwise it could have been in Rome perhaps, or another place, or in Africa, or whatever. The ICC, however, can hold meetings anywhere. It's mobile, if it wants to be. But the permanent seat is in The Hague. Most countries agree that that should be the place. Okay? Which crimes are covered? Let's do that first. Then we'll look at the procedural aspects a little later. Okay. Otherwise we run out of time. Genocide. That shouldn't be surprising. Crimes against humanity. We haven't gone into real detail, but we don't have time really to go in great detail. So I'm trying to give you an overview. War crimes. And, look at this, aggression. But the crime of aggression has not been defined for purposes of international criminal law. And it's a very challenging quest how to deal with that. In fact, our coordinator here, Gruya, I don't know if he's there or listening, but he is doing his doctorate, actually under my supervision. I'm very proud to have him as my student. On the crime of aggression, how could it be developed and how possibly could it be implemented? Very tough question. And so that's being worked on right now also by the Assembly of State Parties to the ICC in New York. There's a commission on that. You see, why do you think aggression should be outlawed? Because there's no point in looking at the symptoms. I don't know if I have a pointer here. Not really. If you look at genocide, crimes against humanity, and war crimes, if you look at those happen when war breaks out, right? Mostly. Not always, but mostly. So it doesn't make sense just to look at the symptoms without looking at the cause. So most states understood you have to try to understand that aggression is also a crime also. The problem is how to define it. That's always eluded the international community. But I think it could come about. All right, those are the crimes. The Rome Statute incorporates the key genocide convention prohibitions. Nothing new there. Defines crimes against humanity more precisely than the Nuremberg, Tokyo, ICTY, ICTR charters. So it develops the law there. Removes any connection between crimes against humanity and armed conflict. In the Nuremberg and Tokyo charters, it was always unclear whether crimes against humanity, like mass rape, for example, or mass killings, whether did it mean that these had to happen during an armed conflict before they were covered by this norm, or also in peacetime, situations technically that qualify as peacetime. So for lawyers, that will be of interest. The ICC statute goes beyond and is very progressive and says crimes against humanity could be committed at any time, and they're prohibited. It also, the Rome Statute establishes that war crimes can be committed in both international and non-international armed conflict. Makes clear that crimes of sexual violence qualify as war crimes. That was never clear before. Why wasn't it clear? Because international criminal law has perhaps been dominated by men. Either they didn't care enough, or because they felt that, well, it was too embarrassing to talk about and we don't want to put witnesses on a stand and these kind of things. That's passé now. I mean, people want to talk about these things and there are ways to handle it. Prohibits recruitment of child soldiers less than the age of 15 years. So there's a limit there. Child soldiers is now a crime, using child soldiers. Unfortunately, the Rome Statute does not prohibit the use or deployment of nuclear weapons. Nuclear weapons, Why? Because some powerful states, nuclear states, said, we ain't going to sign this if you prohibit us from using nuclear weapons. So, okay, the rest of the country said, all right, fine. We won't cover it this time. Hopefully we'll cover it in future. Okay, let's go. Turning to the structure of the court. The ICC has 4 organs: presidency, pre-trial, trial and appeal divisions, office of the prosecutor, registry. I mean, this may not be of interest, but I'll go through the structure so you have it. There are 18 judges, prosecutor elected by an absolute majority of the state parties, judges elected by the Assembly of State Parties. It's supposed to be a gender balance, geographic representation, representation of the principal legal systems. It's not an American court. Well, actually, they're not even a member. It's not a European court. There are a lot of Latin American countries. All of Europe's represented. A lot of African countries. It's only Asia. Only Asian countries where there are very few ratified.
What about the Middle East?
Jordan. I'm not sure about Yemen. Turkey's not really Middle East, but Turkey. Cyprus on the UN map well, no, Cyprus is still Asia. Egypt might be. I'd have to check it. I don't have the list of ratifications here. Number of states. Bahrain, I believe, is there. Iraq is not. Afghanistan signed. I think they were ratified, perhaps. So there's a few. It's not so bad. And Jordan, I must say, was very active in the Rome negotiations. It was actually Prince... No, it's actually became a friend of mine, but I never pronounced his Ziad. He's not a crown prince, but he's heading the Assembly of State Parties. He's been very active there, and the Jordanian people, and some Saudis too. Currently, 7 out of 18 judges are women. Actually, that's the best representation we have on any international judicial body. It's not exactly half. You need 2 more, but it's better than we've seen historically, so I'm happy to see that, at least that. The prosecutor can initiate investigations on his or her own motion. That's good. Prosecutor is an independent prosecutor. Can gather information from any reliable source. That means, that's your question, can he or she consult NGOs? Yes. As long as they're credible and reliable, and that takes, I mean, maybe they have consultative status, maybe they're known or whatever. That's very good. But the prosecutor must, otherwise the prosecutor might go crazy. The prosecutor must request a pre-trial chamber for authority to proceed on an investigation. States they said, listen, we want it to be a strong prosecutor, but what if you had a prosecutor that was overly zealous, that was overly, activist? That wouldn't serve the purpose either. It would just draw the ICC into disrepute. That could happen. States said, look, there has to be judicial oversight, which is a good thing. Sure enough, this pre-trial chamber, which is judges, is a gatekeeper, can say, look, you don't have enough information here. We don't have enough grounds to proceed, so can stop the investigation.
So he must consult the judges first?
Actually make a formal application and say, I want to proceed on my investigation. I have all the information. I have to proceed. Can I proceed? And they say, yes. Or they say, no, go back. You can apply later, but we're not satisfied. There's enough to proceed on an investigation. Okay? Let's go. The pretrial chamber has to determine, here's the test, whether there is a reasonable basis to proceed. Otherwise, it's to knock off, unwarranted investigations. Otherwise, you have one prosecutor pointing his or her finger at states of the world. Just one maybe person who's become demented. That's a risk. You have to have some checks and balances in the court. This is one. Okay. At this stage, victims may make representations to the pretrial chamber. So it's an open process. It's not a closed, ICC process. It's also open. And sure enough, I met the deputy prosecutor actually coming through Hong Kong. He came through to visit Asian institutions and to find out things here. He's a very nice guy from Belgium. And they will go out and have their networks out there. Not only that, but the UN Security Council, this is another check, but it's a serious one, can defer an investigation into a situation for a period of 12 months. You see, Security Council members at the Rome Conference said, look, the Security Council should be able to stop the ICC. And many countries said, no way. That's a political body, this is a judicial body. They said, we're not going to cooperate otherwise. The reality is that the Security Council does express the political reality of the world. There's some powerful states, the big five permanent members, and others now that aren't represented there, the EU, Germany, Japan. And so that has to be taken into account. So sadly, the UN Security Council can defer investigation into a situation. Maybe they want to do something on it themselves. Maybe they just have friends. That's not good. They can also renew this deferral. In fact, the Security Council has adopted resolutions 1422 and 1487 already, which was a renewal, to exempt all nationals of non-party states serving in UN peacekeeping forces from ICC jurisdiction. That was the Americans that pushed that through. They pushed and they pushed and they pushed. They said, we're not going to give any money for peacekeeping. It was a Bush who said, unless the Security Council exempts peacekeeping missions, which means our American nationals, from prosecutions. That means if we commit some war crimes, no problem. We'll prosecute them ourselves. Now, people from the beginning of the Rome Statute, including me, could never understand the American position. It is completely and utterly illogical. Because the U.S. has a functioning judiciary, a military justice system. Remember, the concept of the ICC was only to prosecute where unwilling or unable. This means that the U.S. is saying we're either unwilling or we're unable to prosecute for genocide, war crimes, crimes against humanity. I'm frankly shocked by that. Everybody's been shocked by that, but they don't change on that. The real reason is they don't want anybody to tell them what to do. In peacekeeping or other places, they want to do what they want to do, and maybe they don't have such good faith in prosecuting their own people. You saw all the Abu Ghraib stuff from Bottigliero's lecture and her ranting about the U.S. probably. The reasons are that those are big violations and they're not being prosecuted properly, and some of the people, there's some prosecutions, but the sentences seem to be very weak. So we have to watch that process. So maybe it's not bona fide. In terms of procedure, if approved by the pretrial chamber, the prosecutor can go ahead and investigate. Follows from what we said earlier. The prosecutor has to notify all state parties of its investigation into situations and may do so confidentially, not to embarrass the state, which is okay. And then there's procedures here. We don't have to look into great detail because I know you'll have questions, so I want to leave time for questions. But there's this process of objections, and there's places where steam can be let out and people can be consulted. If you're accused, you can go and object against that and give reasons against. So, you can challenge the case early on by an accused, a state having jurisdiction over the case, or where a state might be involved for other reasons, may have custody over the offender. It's only to say that there are checks and balances so that once an investigation is started, it can be stopped if there are good reasons. Supposing a state says, oh, we know this offender, we have him or her in our custody, we will prosecute. Why not? The ICC doesn't have to take that case. That's a good reason, actually. It's costly otherwise. The court may seize jurisdiction wherever prosecutor initiates investigations. Here, a state party refers a situation to the prosecutor. So anybody who signs and ratifies the Rome Statute can refer a situation to the prosecutor. But it will only cover state parties. Or the Security Council invokes Chapter 7 and refers the situation to the ICC, whether it's a state party or not. So let's say a state doesn't sign, doesn't ratify. The Security Council can still act, just like it has with regard to Yugoslavia and Rwanda, and refer a situation to the ICC. So that ad hoc approach still, in a way, got folded into the ICC. The problem is, what do you need? You need the 5 permanent members. So the U.S. has the power card here. It pulls out his card and says, we don't want to refer a situation to the ICC. We're not a party, and we veto it. So it's holding the cards on that one. It's got a very powerful position. The pre-trial chamber can review a decision of the prosecutor not to proceed. In essence, the pre-trial chamber can reactivate an investigation. Come on in, please, Sanjeewa. This guy already knows everything about international criminal law since a student of mine, and also he has been lobbying ICC throughout this region very, very much, and he's going to talk about that as an expert. So he knows a lot about this. So he'll bring everything I'm saying about the ICC into the home context of Asia after our break. So what I'm saying is that the prosecutor, the pre-trial chamber, can reactivate an investigation. Let's go on. The trial, okay, must be fair and expeditious with fair trial guarantees. Much better than Nokia, Tokyo and Nuremberg, and even the ICTU and ICTR. Must be public. And thanks to the Canadian government delegation in Rome, lobbied very hard for this. And the whole ICC has to apply international human rights standards. So the ICC itself doesn't violate human rights. Because there are some cases in the ICTR and the ICTY where there have been some pretty serious violations of the rights of the suspect. Also, the ICC has no trials in absentia, has a comprehensive mechanism for victims' redress through a trust fund. Dr. Bottigliero has just written a book on that, which is published, as I mentioned to you before. Extends a full right of appeal against convictions on an error of law, unlike, in Nuremberg and Tokyo. The ICTY and ICTR, every single case that came up was appealed. Every single case. There is a right of appeal at ICTY and ICTR. Each case has been appealed. The statute entails mandatory obligations on domestic jurisdictions. That's something very important. The ICC relies a lot on the state. It can't do everything. It's just, Antonio Cassese said, who was a judge at the ICTY for a long time, a famous professor, said the ICC is like a monster without arms and legs. It's the body's in the Netherlands, but it can't do anything. It's in the Netherlands. So the arms and legs are states. So it has to, try to ask the state to do this and to do that. And the coordination is going to be the thing. Otherwise, you slap itself silly, and fall down and everything else. I mean, it's kind of like a Frankenstein monster. So it really, Part 9 of the statute puts all the emphasis on these coordination problems. All right. As for penalties, the statute does not apply to persons under 18, first of all. There's no death penalty. Life imprisonment is the maximum. And there's a list of states that are willing to provide detention facilities. And the Netherlands also, you can stay there. Better to stay there than some countries. There you can watch television and stuff. For example, it's better to be an ICTY criminal than to be an ICTR criminal. And it's better to be prosecuted by the ICTR than to be prosecuted by the Rwandan government. Because I've been to those jails. I wasn't a criminal, but visiting them, and they were heartbreaking. People standing up because there's no place to sit down. Nothing to... they had food, but just horrendous conditions. Cramped. 15,000 people in a prison for 5,000. So people jammed into cells for 5 years, 6 years, without a dossier why they were there. Anyways, I don't want to extempore. Many died. Many babies born in prison there. The principle of non bis in idem, that you cannot be tried or punished twice for the same crime. A sentenced person may not be subject to prosecution, punishment, or accession to a third state. In other words, you can't be tried over and over and over again. If you're done with by the ICC, or you've been let off, you go home, you relax, you watch the Oprah show, or whatever it is you watch. But you don't have to be tried over and over. Otherwise, that's a violation too. So non bis in idem and there's other things. As for financing, just to wrap this up, because I know you want to have some questions, ICC is financed out of assessed contributions made by state parties and UN funds from the General Assembly. States can also make voluntary contributions. The EU has made a lot of contributions, and they're the ones that are making this ICC function very well. Finally, the Rome Statute does not allow for reservations to be entered against it. Remember, it's a treaty, and treaties normally can be reserved against. You say, I agree with everything in the treaty except this. For example, some countries say, I agree with the genocide convention and they sign it, but they say, this is the part on genocide I don't agree with. So that says genocide should be prohibited. We agree. We think genocide's okay. So they sign and ratify the treaty, and then afterwards they say they try to reserve against key provisions. The Rome Statute has no reservations. Then there's going to be a review after the statute's entry into force. Well, it entered into force in July 2002, so that means in July 2009 there could be a revision of the statute. For example, terrorism is not covered. Maybe that's something, because there's no definition, maybe that's something that could be worked on and included in the ICC. There. Those asterisks signal to me and to you. I'm finished my presentation. Questions? We have 5-6 minutes.
Is there any time bar for prosecution? And
Yes?
what is the criteria, what is the measures for genocide? How many people you need to kill me to cover the genocide?
All right, 2 questions. So first question is time bar. Well, the Rome Statute does not apply to any situation or act prior to the entry into force of the Rome Statute for that state party. If the basis upon the of the court's jurisdiction is according to the state that it signed and ratified. To put it simply, give an example. If India signs and ratifies the Rome Statute, I laugh because it'll never do that probably. They've been against it for a long time. But let's say India did ratify the Rome Statute. Then they ratify it on July 1st, let's say, 2006, and they commit a bunch of crimes over in Ayodhya. They massacre a bunch of Muslims in 2003. Those crimes don't come in. It's only henceforward. Well, now that we have in India the BJP out and we have the Congress Party, maybe they will move on the ICC. You never know. And your other question was on genocide. How many people do you need to kill? 0. Because when we looked at the Genocide Convention on Monday, we saw that preventing births within a group qualifies as genocide. Attempted genocide is also a crime. So those come within the rubric of the ICC also. And otherwise, you would have the situation where we say, well, they haven't committed it yet, they haven't committed it yet, they've done it, they haven't done it, they haven't done it. They wiped out everybody, now let's prosecute them. There's no point in having a crime fashioned that way. So it's supposed to be preventive. That's why it's done that way. The main thing is the intent that is important for the crime of genocide. Yep?
Follow up on that question. What if the effects of a genocide committed prior to the treaty going into force linger on and have some discriminating effects on that group that was subjected to that genocide, say, 20 years ago?
That is an excellent question. You know why? Because it's been troubling lawyers for a long time. And there are 2 answers to that, really. And it actually has been used in the Jessup Moot Court competition in Washington, where Hong Kong came 3rd in the world, actually. And one of the things is, well, it only covers acts committed after the entry into force of the Rome Statute for the state party. But you may have some acts that have a continuing character. So if you look at it that way, those might be swept in. Or where the intention happened before and the actus reus, the act of the crime, still continues afterwards. The difficulty is the effects doctrine. Supposing the intention and the act was done completely before, that's the case you're really bringing up, and only the effects continue. The question there is going to be difficult for the court. Probably it doesn't come within the rubric of the statute because there's so many crimes, after all, that have been committed before, and the effects linger on for 50 years or 100 years. So if they were too broad, they would be going very retroactively. So they're not going to take a very broad view of the effects doctrine, because there is a doctrine that says you should be able to assert jurisdiction where the effects are continuing. So the question is going to be where to draw the line. If it was just one day before and the crime is still being committed in a way, in effect, but then we have to look at individual cases to determine that. But so I can't say very much in the abstract. All I can say is that if the act is completely finished, it's only effects that continue, I think the court would probably say, sorry, it's a done deal, we missed it. If it's like of a continuing nature that started before, those they will take. So I think there has to be some continuation. Effects, in my opinion, will not be enough. Intention is part of the crime. There has to be always mens rea for criminal, for a crime, and actus reus. So there has to be the intention to commit an act. For example, if you killed somebody, which you didn't mean to, happens all the time. People go this way, and they nudge somebody and they fall off the cliff. Ah, they didn't even notice. They say they walk home. Right? These things happen. It's like Bugs Bunny show, right? If you didn't notice that you had no intention, you shouldn't be guilty of murder. You should be guilty maybe of stupidity or clumsiness. That's not a crime. So if you had the intent to kill a person, and then you kill them, that's basic criminal law. That there has to be the intention and the act. Any other questions, particularly on the ICC? Go ahead. No, resolutions of the... They're not reservations, because the Rome Statute itself, as we saw there, allows for the Security Council, it recognizes that faculty, that a deferral to a situation could be had. So a reservation is something technical where a state exempts itself from a particular provision legally. But that's not what this is, because there's a mechanism for it. It comes to the same effect, but legally it's distinct. Because there's a mechanism that was foreseen by the Rome Statute. Okay? What you're talking about is it really comes to, in effect, they're reserving, they're exempting. It's not, but legally it's not the same thing. But the effect is the same. Anybody else? It's a good point.
Can ICC act as a court of appeal if we are not satisfied with, for example, the result of domestic court? Can we bring the case to ICC?
It's not meant to be a court of appeal in a strict sense. So, because it's for two reasons. It doesn't form part of the hierarchy of any state, or even as a superstate, and there's no right of appeal so that's not true. It's only where there's an unwillingness or inability to act, or if it sounds like a court of appeal where the prosecutor and the state put on a trial that wasn't fair. So in a way, it sounds like an appeal from that process, but it's not. It's saying those original cases were never really done. Those trials were not real trials. They never happened in a way. They weren't genuine, but they were fake. You see what I mean? There's a difference there. Yeah? Go ahead. Absolutely. There's the appeals chamber. There's pre-trial chamber, trial chamber, and appeals chamber. And I went a bit quick, so you did probably catch it. On any material fact of mistake, let's say that wasn't known, a fact comes out which maybe exculpates the person, or on an error of law. So those are two grounds for appeal. Anybody else? Otherwise, I know you're suffering from the cold. I can see that. And so I'm going to allow you to get your warm-up tea and coffee right away. And then we have a really interesting presentation from Sanjeewa, who's coming up, who came in. Nice to see you there. Okay, thank you very much. Instead of just jumping into the International Criminal Court, I would like to lay the foundation again so you know the history of where this field came from and where do these norms come from. And I'll try, I know last time when I did history, some people said they really loved it, but some other people took a little nap too. I mean, you know, history has got it's very important as an explanatory thing, but bear with me. And it does explain a lot. It explains the purpose and rationale of international criminal law. And also, it gives a hint as to its strengths and weaknesses. I have my name thing here, and it reminds me of what my last name means. And now that I have a United Nations official here on official mission, I might as well explain that. It means Session of the United Nations General Assembly. So, okay, just let this load, which I think it's doing, yeah? And then push F5, and we're on. Thank you very much, Korea. This guy is great. Without him, this course would not be going anywhere. And Mark King, I want to give a thanks to. Now it's a popularity contest between those two guys. I don't pretend to be popular in any way, so don't worry about that. I know that I have my own. Okay, here we go. Lecture 4. Ready? Let's go.